Welcome to the Employers Legal Lounge with your host, Michael Sullivan and Associates Managing Partner Eric DeWong. Each month, we dive deep into a specific topic to provide you with valuable insights and guidance for navigating the complex world of California employment regulations. This podcast is provided for informational purposes and does not constitute legal advice. Only your attorney, with complete knowledge of the facts and circumstances of your situation, can determine how the relevant laws apply. Now, on to the episode.
Welcome, everybody, to Employers Legal Lounge, episode 4. My name is Eric DeWong, managing partner at Michael Sullivan Associates Employment Law Department. Employer Legal Lounge is here for you to get the latest updates on employment law and legal updates for California in general, mostly employment, but where it crosses over into other laws as well. This is for insurance carriers, HR consultants, HR in general, employers, brokers, all of those that are interested in navigating these wild and crazy laws that we have in California. So before we get to our special guest today, and as you know, we always have a special guest, a leader in the industry. A few notes about PIRA. I just came in from a conference from PIRA. It went great in Riverside for CELU 24. And we have some updates on for those interested in the PIRA College Relations Committee. For those who don't know what that is, it is our committee that is working with HR students in different universities and colleges, trying to get the mentors and experience out there to be our next leaders in the HR community. Right now, our committee has been working very hard, and we have these different chapters that are working with students on mentorship programs. We are looking right now for mentor volunteers out there. So if you're an HR leader, a professional that wants to give back to the community, please let us know. Let me know if you'd be interested in mentoring these students. They will greatly appreciate it, and it is a lot of fun. So let's get down to business and our subject today. Today we have, of course, somebody who needs no introduction, but I'll still introduce him. It's Mike Sullivan of course, Michael Sullivan and Associates is joining us today. For those of you who don't know Mike, but you should, he is the founding partner of our firm, Michael Sullivan Associates. He knows everything and does everything workers' comp, all the things that I don't do, since I do only employment law. So we meet somewhere in the middle. And he is also the owner of IEA, Insurance Education Association. As many of you know, that is our resource for HR and risk for education and certifications out there. And if that wasn't enough, he also started something that most every person who works in workers' comp in California uses, Sullivan on Comp. It is the Bible, from what I'm told, for workers' comp. Judges and workers' comp use it. All the attorneys use it. And Mike started that sometime back in 2012. So welcome, my friend. Welcome, Mike.
Thanks. Boy, you put all that in there. It sounds like I work really hard.
I know, doesn't it? See, I read all the notes you told me to read. So
good. Yeah. Got my rhinoceros here, which is our logo.
Yes, I don't have the branding today, but yes, you're representing for both of us. I like it. So as we start, what we do in the legal lounge, my friend, first is an opening cheers. And what's your beverage today?
None of your business.
Okay.
It might be mezcal.
Mezcal. Hey, mezcal. Mine is a Dos Artes tequila. So we're thinking the same thing.
Sounds
Cheers.
good. Cheers.
Cheers. All right. Okay, everybody. So what are we going to talk about today? We have captive for us the guru of workers' comp. So I want to start with workers' comp and really this crossover between workers' comp and the trends that we're seeing out there. And then we'll get into a little bit of how it goes into employment law. So my friend, what are you seeing out there and the trends out there for workers' comp? What the attorneys are dealing with, what our clients are dealing with these days?
I have to say, it's kind of all quiet on the Western Front with workers' comp. We went to those major reforms in the last couple of decades, and they've been implemented. One thing that is and so we don't see a lot of news about workers' comp these days. One thing that is happening is that the COVID presumptions
Yeah.
have been repealed, and so by operation of law. So that's pretty significant because not only do they come with a burden of proof on the employer, but they came with all these requirements and penalties.
Yes.
There was you normally have 90 days to deny a case, and in those some of those cases it was 45 days or 30 days. And also there's special penalties up to $50,000 for bad faith denial, and that was pretty scary.
And that's
And there
gone.
was all this work that you had to do as an employer in order to track whether there had been an outbreak at one of your work locations. So all that stuff is just gone, baby, gone. And I'm doing a webinar, I think, in the next couple of days with my co-author, Sure Log. And the striking thing about it is that it seems to, the repeal, that is, seems to apply to all dates of injury. There was this case called Wiener. I'm not kidding you. That was the name of the case.
Can't make that stuff up. Go for
Way
it.
back in the day when they repealed vocational rehabilitation, and there was millions and millions and millions of dollars in back vocational rehabilitation maintenance allowance, which is like temporary disability, that was outstanding and owed in the industry throughout thousands of cases. And they repealed voc rehab, and we took Wiener all the way up to the Court of Appeal, and they held that those benefits weren't owed anymore. And that was viewed as a real substantive taking away of a benefit. But the Supreme Court said, hey, the California Constitution says that the legislature has plenary power to do what it wants with workers' comp. And some people think that that means that the legislature has plenary power to do what it wants with workers' comp, including taking things away. So in these cases, if there's no final order, that is all the way to the Court of Appeal, if it's still an issue, these presumptions,
Right.
and all the things that go with them, I'm thinking, based on precedent, that all the presumptions are just gone. And you can reapproach the case, whatever case it is, with a new standard of proof, regardless of what stage of litigation it's at.
So I'm assuming that the burden back on the employee.
Yes, it does. Yeah. But think about it. You're an applicant's attorney, you have a presumption, you go to trial, you win. The defense attorney does a recon, the recon's denied, you file a writ. And now the standard of proof that was used to prove the underlying case no longer exists. So what does that mean? And so I'm looking forward to exploring that more with Sure in our webinar.
What date is that? Just so we know. When is it coming up?
The repeal or the webinar? I don't know. It's pre-recorded. But it's being recorded, I think, next week.
Fantastic. I'll put that out there as well.
Yeah.
For those interested in that. And it is, and we get those questions, quite a bit, especially, COVID issues still coming up. And, a lot of those have also been, have expired in the employment law sector and OSHA sector as well. Something we still have to keep an eye on. There's, guidance from the California Department of Public Health that we still keep an eye on as recommendations. But largely, these have gone by the wayside. But, when we were in it, because you and I did dozens of presentations during the pandemic.
Well, we did a book. If you put it out, probably 300 pages, right? And you and I did that, and we had thousands and thousands of people looking at that book during COVID. And we did, I think, through Sullivan and Comp, we did 30 webinars.
Yes.
Doing one every week, just on COVID and the law. And it was so, so new and so unknown that we were really going crazy. I was just talking to Jake Jacobsmeyer, and he got COVID while he was on a boat at the beginning of the COVID crisis. He went into a coma for a month.
Wow. Yeah.
And he thought when they woke him up, it took him 3 days to convince him that he was not in Las Vegas, Nevada. So man, it's you remember those times, man? Remember those couple of years? It was
it was the Wild West again
crazy.
In the law, because it was changing every week, and that's why we're doing a weekly webinar.
Yeah.
And the law from the week prior became irrelevant because they changed it. The legislature was just doing these emergency standards all the
Yeah.
time. So, it changed all the time. So I'm
Yeah.
sure the fact that it's quiet on the front for workers' comp is kind of nice because it hasn't been quiet for the last few years.
Well, yeah, they still want us to close cases fast.
They still want to close cases fast, and it's still. I mean, it still comes up in my world. I don't know if it does, as much as in yours with these presumptions gone, but COVID still comes up, and whether or not it's a disability, and what do we do with this? There's no sick pay, so we deal with this still in a lot of ways. We don't have these mandates, but we have mandates under ADA and FEHA for if it's a potential disability, right?
Sure.
And then we have, um, employers saying, well, do they catch it at work? And do we have to give them a claim form and all these types of things? So one of
Long
the things,
COVID, there's long COVID, and what's
yes,
that, and does it exist, and what does it mean? And
right. And largely, at least in my world, what we do is we just go by the medical note. What does the medical note say? What's the accommodation, those types of things. And we follow that. We don't try and read behind it. But I think the question from the workers' comp component, and I get this on all sorts of, conditions, they come in and their wrist is apparently hurting. Do we give them a claim form because they type all the time, right?
are you
And
asking me?
and I am going to punt this to you because I don't think people necessarily believe me when I say what I hope you're going to say about the standard for doing the claim form, because this creates not only problems in workers' comp when people pull the trigger too quickly, it translates potentially into employment law problems as well.
It reminds me of a story. This was like 20 years ago, but I got a bunch of cases because an insurance broker went into an employer to give a sort of a training on workers' comp and to describe cumulative trauma injuries. And at the end of the training, 4 employees approached the employer and said, "You know what? I need to file a claim form because I because I think I have a cumulative trauma injury." And I thought, oh man, what are you doing over there?
Oh man.
Yeah.
So,
But
so
if you're asking me what the standard is for when a claim form needs to be provided to an employee, there's sort of a difference of opinion in between the case law, the attitude of the Workers' Comp Appeals Board, and the attitude of the audit unit. But I believe that the case law is controlling. There's this case called Honeywell, which is a Supreme Court case. I think it was 2005. And in that case, a woman calls the employer, the wife of an employee, and says, my husband's checking into a mental hospital because of what you've done to him with all of your head games. And they looked at the statute, and the statute says that the employer, in order to provide a claim form, has to know that there's been a work-related injury. And the applicant's attorney was arguing that there was knowledge, or at least absent that, a reasonable certainty on the part of the employer that there was some kind of work-related injury based on that evidence. And the Supreme Court held that there was not knowledge, that the Supreme Court has held that the employer did not have knowledge under those facts. When she calls and says, "You have driven him crazy with your head games," and off he goes to the hospital, that did not constitute knowledge of a work-related injury. And they said explicitly, reasonable certainty is not enough. You must know that there's been a work-related injury. So that's, the employer community was a big fan of that decision.
Well, I mean, hey, a win for employers, good for you in workers' comp. We don't get many of those in my world, right?
Yeah.
So
Well, we don't get any in our world either.
yeah.
But the thing about it is that the Workers' Comp Appeals Board being what it is, there's a lot of subsequent lower level cases, board level cases, where you would think under that standard that there would not be knowledge, but nevertheless there's found to be. And we have an audit, as our firm represents just about all the TPAs when the audit unit comes calling and does consulting and even litigating with the audit unit. We're in the first trial that audit unit's ever had right now.
Really?
Pilar Mitchell up in Fresno is taking the audit unit to trial based on a dispute over their findings on an audit. And the audit unit has a tendency to say, well, you should have provided a claim form. But in my mind, the legal standard is clear. And another thing is, if you give let's say you have a relatively uneducated employee who's not a legal sophisticant,
Mhm.
right? If you give them a piece of paper, what do they do with it? They fill it out. Yeah, they fill it out and then they give it back to you.
That's true. No, that's
And then
true.
you have a claim. So, I always advise employers to sort of hold their ground. If you see someone fall down and break their back, give them a claim form. If
Right.
some employee says, Bob has a hurt back, you don't go ask Bob, well, how'd you hurt your back?
Exactly. And this
Uh,
is where I get some, issues. Workers' comp is different than our world. We also usually wait until reasonable notice, some type of notice that there's a disability, some type of condition, right? And they conflate that and they say, well, they type all the time and they have this, this wristband on for carpal tunnel. Do we give them a claim form? Did they ask for a claim form? Did they say that wristband is, not from playing tennis too much? Or it's actually from work? And the answer is no, but are we creating risk?
it's
And
so crazy. I hear defense attorneys, not from our firm, but
yeah,
from other firms saying, first things first, make sure everyone's got a claim form. And I'm always thinking, why? And then
yeah,
because they're trying to establish the statute of limitations defense. But look, in Sullivan on Comp, chapter 6 is all the different ways the employer is going to lose the statute of limitations defense, right? And there's like 50 of them. So I always say, when you have a statute of limitations defense, you have to find out ahead of time why you're going to lose. So, because you just can't in workers' comp. I mean, I've done it a couple of times, but you really got to throw the needle. So my judgment is that provision of a claim form where you don't actually have knowledge is a mistake.
yeah. And Honeywell's controlling. It's California Supreme Court, right? So, this is the one area, and I tell people, but they're like, "Oh, you're not a workers' comp attorney, Eric." And I actually quote Honeywell, and because one of the one things I know about workers' comp, and I say, don't, this isn't an Oprah thing where you get a claim form, you get a claim form, you get a claim form, right? It is, something that's very decisive in actual knowledge. This is one of those places where you actually have to know. So use that
Right.
in that sense, right?
I agree.
Use common sense also, but also use, that standard as the tether. And if you're doing it for one, you have to do it for everybody. So being
Yep.
consistent is, really key. You mentioned, TPAs, and I wanted to bring this up because this is coming up more and more, and we're getting cases in about this. I mentioned this, I think, on episode 1 of the podcast, but I'm going to, bring it up again because we're now seeing cases on this, which is what we've called the Rains case. It's Rains versus HealthWorks Concentra.
You told
And
me about that case.
yeah,
I
it's
like that case.
nobody likes that
Is there
case.
any chance we can just pretend it doesn't exist?
Let's do that. Let's just forget about it. And and the thing is, most people don't know about it. Still, employers don't know about it. I go to HR conferences a lot, as you know, I've done 4 in the last week. And when I ask people who know about it, there's a handful of people, and those handful of people that know about it because they've listened to our podcast or they've seen me in a conference somewhere.
Yeah.
So this is a case that just came out in August. Just basic facts are, Rains goes in, and she's a kitchen worker, public entity. They ask, everybody to go and get a conditional offer of employment. They do a med eval, and they do that through Concentra and HealthWorks. They go and do it. They spend about a half an hour there, right? And then she fills out a form. So she fills out this form, and she's offended by this form given by Concentra and HealthWorks, which says, and arguably there's some things in there that asks about, your menstrual periods and all these types of things, which are kind of odd questions. And I still haven't figured out why those questions are in there, but I'm not going to try and read behind that. What the real important thing is she said, hey, I'm offended by this. This is, violating my rights. This is, and this is a violation under the Fair Employment and Housing Act. So I'm going to sue you, HealthWorks and Concentra, under the Fair Employment and Housing Act. And they
Based
say,
on the idea that you're an employer just by doing the employment screening.
yes. And in Concentra, responds going, hey, we never gave you a handbook. We never gave you an offer of employment. We've only
You don't work here.
you don't work here,
Yeah.
and we don't even know who you are. So how are we your employer? And the argument was, you did something for the employer. You're a third party. So this goes to the Ninth Circuit, federal court. Ninth Circuit goes, oh, this seems like a pretty clear case. Doesn't sound like an employer. But wait, hold on a second. It's California law, right? You guys are crazy over there. I'm going to send this to the California Supreme Court. So nothing good comes from the California Supreme Court for us. But even knowing that, when I saw this, I'm like, hey, this case, there's just no way. Come on. But August, Concentra HealthWorks, you're the employer. Third parties that employers hire out to do these types of things, anything an employer might do or tether out somewhere else, can be under the umbrella of the Fair Employment and Housing Act, discrimination, harassment, all of those wrongful termination, failure to accommodate, disability discrimination, all of those things they can now be responsible for employees they never thought they had. So what does this mean? And what is, the people who are in the know are really hustling right now because, hey, we have all this other exposure, HR consulting firms, third-party administrators like the ones that, work in workers' comp between the employer and the carrier, and they're handling all these medical notes. Insurance carriers themselves. These are the types of cases we're getting in, and the plaintiff's attorneys under every rock in California are using this to say, hey, we have another pocket to pick out there. And this is really generating. So I'm getting, I've seen at least 3 cases come by my desk. I know there's many, many more. So, I guess the question is, do we, what do we do as, the attorneys, in this situation, dealing with third-party administrators and, telling them where the line is, right? Because, sometimes, the employer asks the TPA for advice, right? Mm-hmm. They say, hey, what do we do with this now? Because they have a medical note that says, can't return to work or permanent restrictions, those types of things. And, of course, you always want to take care of the client. So the TPA says, oh, it sounds like you're good, right? Type of thing. But by doing that, they are now in this reins world where they're potentially the employer. If they get it wrong, they're in another pocket.
You really think that under reins, the TPA might be considered an employer by giving advice regarding return to work?
Yes, 100%. That's exactly the cases we're seeing.
Wow. Exactly
the cases we're seeing. So, in doing that, I've spoken to, multiple of our clients that do the TPAs. And, my recommendation is, hey, this comes down to the contract, right? Of who has responsibility in these cases, because you can still get brought in, even if you do everything right and you don't give the advice, they might still try and bring you in. So it comes into the negotiation of these agreements with these employers and how you're doing it. It's harder with public entities. You have JPAs and all this kind of stuff and the mess. But that's where part of it is. But it's also about policies for the people handling these. Hey, right. Where's the line for you, right? And I know for us, and when because we have a workers' comp department, we have our employment law department, and we don't tread in each other's world, right? What we do is when the employer or TPA goes to a workers' comp attorney and says, hey, so what do we do about this return to work? They go, hey, that's not what I'm here for. I'm here to defend your workers' comp claim, but talk to Eric. And if we're engaged, then we talk about that because it's a whole separate thing. So we're not getting in that mess. But
the two areas are so deeply enmeshed. I mean, in order to defend against a voucher, for example, or defend against liability for TTD, the applicant's ability, the injured worker's ability to return to work, or whether an offer of work is made, is an integral part of work. There's forms that doctors fill out, and determinations are made in regards to liability for workers' comp benefits. Advice is given.
Yeah.
And the two are just so inextricably linked that you can see how this could really turn into a mess really fast.
It really can. And of course, the allegations that are going to be out there are going to be very broad, and we have to defend it. And somewhere along the line, which goes to the appellate courts and the California Supreme Court, if they ever take it up, are the lines that will be drawn for reins. But we have none right now. Right now, it's, kind of the wild, wild west of this new employer world. And, what do we do with it? We're still, if we get sued on it, we still are probably not going to get dismissed on a motion for summary judgment necessarily.
God, I love California.
It's a train wreck, right? So it's, it's one of those places where I'm never surprised about these cases that come out. But this one really did, turn my head. And
I wonder how that might be interpreted on a federal level for like ADA stuff.
Well, they used some cases in different circuits that were the Ninth Circuit, but other circuits that had some language. It was mostly dicta, which for those out there, it just means they're kind of talking about it, but they don't it's not a real ruling. suggesting that these laws could get tethered out to third parties if they're doing work for the employers. But it's never been in federal law, the law that employers are these third parties under the Americans with Disabilities Act. That's not the law, even though they cited some federal opinions. So this is new in the United States. Of course, California is always the first, right? The only other first is San Francisco. Of these types of things, and if you have San Francisco employees, beware.
Hey man, say what you want about Gavin Newsom. He has great hair.
Yes.
And great teeth, I gotta say.
And that's where it ends. Yeah. Yeah, I mean, these are the kinds of things we have to stay on top. So I think the message, I don't know, I mean, the message internally for, us obviously is to at least let our clients know, the third party, TPAs know, employers have to know, on, my end, because they have to know that these other, organizations are potentially tethering them by their conduct to liability if they do it wrong. Right? HR consulting firms, for example, which, happens a lot. So that again comes down to the agreement. My clients who are employers, they're putting in and building in, hey, if you muck this up, we're not responsible. You are. And they're ahead of the curve because so few understand this yet. Within a year, they'll really understand it because the lawsuits will be out there. But right now is the time to negotiate these contracts. Sorry, I got on my soapbox about this, but this has been.
Hey man, it's a hot topic. People need to know.
Yeah, but let's get to something that is more.
Now, wait a minute. Are they going to sue the lawyers too? Because that's un-American.
It is absolutely un-American. So this is my thought on that. I think, and this is where we probably need to be as lawyers in California. When we're doing these things, we have to have a client relationship, right? An engagement, as opposed to, and when we're doing presentations like we're doing now, and we do otherwise, we have these disclaimers. Hey, we're not telling you this is what to do. This is for education, right? We're not your lawyers. If you want us to engage, then we engage, in it. If we're under that cloak of the engagement, I think we're largely protected in this, right? Because otherwise employers would never be able to give an employer advice at that point. They'd always be an employer. So I'm pretty sure, I'll go out on a ledge, even in California, that will never be pierced. But all these others, insurance carriers who really don't give advice to employers, they're not known for that, right? I can imagine, accountants will probably be also protected because they're supposed to give, certain types of advice and stuff like that to employers. So these certain professionals that have these engaged relationships probably will, but others not so much. So who knows?
Hold on, I gotta make a call about my EPLI insurance and my malpractice insurance.
Yeah, and that's another good point, because people think, hey, I have EPLI insurance, but does that EPLI insurance cover you if you're an employer for somebody you never thought you were an employer for, just because it's under FEHA? So will they even cover you for that? So you need to go to your policies as well. Good point. Will that policy actually?
I was just making a joke, but
I know, but you know me.
I made a good point. So that was lucky.
So one of the main reasons, of course, workers' comp, but one of the really big reasons I wanted to talk with you today is AI in the world. And the reason is, and we've talked about this a long time ago, and you started, I remember you calling me and saying, have you done this ChatGPT thing when it first came out? And it was, still people couldn't get on, all that kind of stuff. And this is the, the new world. This is the way it's going to be. And I'm like, oh yeah, Mike, I'll get better. And I will tell you that has translated to be very, very true. Because this is a tool out there that people are using for all sorts of reasons, good and bad, out there. But on Sullivan on Comp, I know we've been integrating that. So tell us a little bit about how AI has been working for workers' comp. It's different in employment law, so don't attach these to employment law issues. We'll talk about that. But how's it working for workers' comp?
Well, when I first heard about generative AI, I knew immediately that it was going to completely change our world. Workers' comp is high volume, highly algorithmic. My biggest gripe about workers' comp lawyers is they can become sort of cookie cutter lawyers.
Yeah.
Because so much of it is so much is according to a complex, but well-defined in some cases, a set of rules, a lot of rules, but rules, right?
Yeah.
And work processes and workflows and all that. And I think probably like everyone else out there, using ChatGPT 4, I used it for days. I played Dungeons and Dragons with it. It was my dungeon master, and it did a great job and a continuing narrative that it completely manufactured out of nothing for me to interact with it,
Wow.
Um,
Well, on
it
the Dungeons and Dragons thing, and also on the AI part, both of those.
right. Well, it passed the bar, it passed the medical boards. I mean, the thing, college students that are using it to write papers, college professors are using it to write lesson plans. It's just a revolution in the level of capability that computers have in all aspects of life. And you're seeing, I just pre-ordered a little badge you wear on your shirt, and it sees everything. And you hold your hand out and you can read your texts on it, and you can talk to it. And it's the beginnings of a virtual assistant, which
Wow.
will know everything, do everything, can order anything, can give you any information, So I looked at workers' comp and I said, in 10 years, about half or more of what we do is review and analysis, right? We get a pack of papers, we do an initial file review. We get a QME report, we do an analysis of that report, write a letter. We get in medical reports, we analyze them under workers' comp law, we figure out what they mean. We modify our perspective on what benefits are owed and what liability is due. We change our recommendations for action, and we write letters, we write emails, and we review and analyze documents. That's what we do. And the other half of the time we go to court or do depots. And I realized that in 10 years, we're not going to do that anymore. We're just not.
What's going to happen?
AI will do it better and faster and cheaper, vastly, than anything any workers' comp lawyer could do today. So we're going to end up going to depots, going to court, negotiating with the opposing counsel, but
The rest, not so much.
the rest is going to be run by artificial intelligence. And so it's just a matter of time. And then I said to myself, there's going to be two kinds of law firms out there, because when we don't have to do half the work, we're only going to need half the lawyers. So there's two kinds of law firms out there, in workers' comp for sure. And in your area, not as much, because it involves such heavy lifting on such particular matters. But in my world, it's going to be half the firms are just going to go down.
Yeah.
And the ones that get ahead of AI are going to do really, really well. And so we made an immediate commitment to going very deep with AI. Now, AI was already part of our practice before the advent of generative AI. There's a lot of companies out there that do things like scan mail, identify documents, save them, forward them. And that saves a ton of time. And we've been implementing that for a couple of years with an outside vendor. And a lot of these, and there are like 3 or 4 independent vendors out there in California that claim to do things like review records. Generally, they do it very poorly because they don't do it in the context of a case.
Right.
Right.
You attorney hat on. Yeah.
Right. So that doesn't really work yet, but it's gonna. And so anyway, so what we decided to do is, in addition to enhancing our use of generative AI operationally and in terms of marketing or forward-facing materials to the world, was to try and we did a lot of that. We're doing a lot of that. Is to create chat SOC.
Chat SOC.
Yeah, Sullivan on Comp, chat SOC. So we've been working on that for about a year, and we launched it this week as a beta. And it's cool. What you do is, instead of like typing in your search terms, you just talk to it as if it were a workers' comp lawyer. And it really works. You say, what does it mean that what is an actual event of employment for purposes of psychological claims? which by the way, 90% of lawyers don't know what that is.
Right.
And then it just gives it to you. You say, well, I have a case and this happened and that happened. What do you think? And the thing says, well, here's there's some factors here that would be actual events. These wouldn't be actual events of employment, and here's why.
And it
So what about this? What about this? And it just talks to you as if you were, not only can it help you look up the law, but it can help you analyze a thought process. And then on top of that, it can generate documentation. So you have to send a letter to a QME and on a point of law, and you just you ask it to give a explanation of the legal point, and it does so extremely coherently. You copy paste it into your letters.
Yes.
You say, write an email about this. It does. So it's really cool. I went around to all our offices. We have 10 now throughout the state in the last couple of weeks. And I asked the lawyers in our firm, are you using this and what are you using it for? And a lot of them are asking questions like, oh, I ask a question and answers it. But a lot of them use it as an advanced search function, because you can just put in your question and answers it, but embodied within it is a link to the section of Sullivan on Comp.
Right.
That applies. You just click through and now you're reading what you want to read. So we're doing all that stuff. And I got to emphasize, Mr. Eric, that this is just the beginning. I mean, when we're developing products that can do a review and analysis of different aspects of the claim as it goes forward, and can be and will become more and more and more sophisticated.
Yep.
So you can feed it a document and the thing spits out an analysis under the law. And I think it's just a matter of time before it will be able to do that in light of
right
particular case you're handling.
And I think this is, really exciting for you and workers' comp in general, because the problem with the other AI versions is they're out of date on law. Like I use ChatGPT to, test it out for law, and it's way behind. It's 2021, type of stuff. There's other search engines that actually, hallucinate certain things.
Well, look, you have that famous case where all the citations were hallucinated.
Yeah.
But ChatGPT-4 created what is essentially a sort of an app store where you can load on your material on top of the overall LLM.
Yeah.
And it doesn't hallucinate, and it's very accurate because it starts with your materials, and it really, really does extremely well.
Yeah, that's what I was thinking because Chat SOC is based on the actual already legal materials that are created.
Yeah.
Right?
So
and so it's not created by outside party. It's already a controlled environment where the information is there from an attorney and a set of attorneys.
And it protects privacy, and
yeah.
but you are basically connected your materials to the overall LLM and its functionality.
Yep.
And it's not limited by the materials either. You can ask it about what's spondylolisthesis,
Yep.
and medical terminology and how it relates to disability, and it can answer all of these questions because it not only has Sullivan and Comp on it, but the whole internet world.
Right.
So it's pretty incredible. And it's just at the beginning stages.
Yeah. For those who don't know what an LLM is.
Oh, large language model, like
yeah.
ChatGPT,
Yep.
Google has one, Microsoft has one, and there's various, we tried them all, and
yeah.
It took a lot of development work, but we finally figured it out. But there's a lot of LLMs out there. Some are free source. They don't work real well.
Yeah.
You know what I did, Eric? When I interview a new lawyer, I ask them about 20 questions about the law. What's the law on this? What's the law on this? What's this rule? What's that rule? Just to see what they know. And then I'll throw hypotheticals at them. Like I was in this situation. What do you think I did? Or here's a situation. What do you do? Mm-hmm. I took that through ChatGPT-4 and it sucked. I took it through Sullivan on Comp and I would have hired it.
Wow.
And I only hire one out of every 3 lawyers I interview. I mean, it was awesome. It gave answers better than I would give sometimes. I wrote the freaking book.
Yeah.
And so
that's it. And that's the control part that I think is exciting. You're not just worrying about, some, random, set of LLMs out there that you're not sure where this information is coming from. It's already a vetted area of law, right?
Yeah.
And it's the, SOC is the treatise. Now, I want to give some, because, that type of scenario is what you want to look for those, listening. If you're using these functions, something that's more controlled like that when you're doing these, I want to do, you to be cautious, because what I'm seeing out there in my world, in the employment law world, is people get really excited, about these things. There was before that I was telling HR and employers, don't Google your employee handbooks, right? Don't Google these things, it's a mess. Now they see ChatGPT and these other, AI platforms, and they're like, hey, I can just feed this into it, and, I don't have to, hire anybody or do anything. I just use this. And so we go through these, these samples, and they are a mess. They are just a lawsuit waiting to happen. So, you have to be careful of where you're getting this information from the employment law standard. Now, if you have a controlled center in workers' comp, I just want people to be careful in employment law. This is an area it's just the beginning. Like, don't do your job descriptions by asking for ChatGPT and put that out there. You're going to get in trouble. It's a place to maybe start, but you need to have the people who understand it to do the work to get through it, to get it right. It's just too risky out there.
For now.
Yeah, for now. And that's
here's the thing. That's the thing about employment law. It's different because you have to tailor it to the individual realities.
It's
of the employer. It's very complex and very particular to the set of facts in front of you.
Yes.
And so I think that, like, things like bankruptcy, wills and trusts, workers' comp, we're going to get eaten by AI before you guys are. But once artificial general intelligence comes,
then it's
all bets are off.
We all need to find other jobs. Yeah,
we're all going to be painting and doing plays and playing video games,
doing all the things that only humans can do for the time being. It's a reality now, and it's going so fast. I mean, which feels like just yesterday you and I had this talk about me first hearing about ChatGPT, and now it's an everyday conversation. So I think
it really is, and it was an odyssey getting to where we are now. I mean, originally I thought I'll have it do an IFR. I paid this company $200,000 to try to design that. They said it doesn't do that. And there's all kinds of false starts and modified visions. And what's striking about it, and I think this is your point, is this exponentially increasing pace on this radically transformational technology.
Yep.
So we are going to be dancing.
We are, and we already are, because I mean, in the state bar, California State Bar is not known for being ahead of the curve, but we have, even at the California State Bar, a whole list of new regulations using AI, right? Yeah. So, I mean, now attorneys are
under— You sent that to me. Thanks a lot. I had to read it.
I know, I'm sorry. But attorneys now have these professional rules of conduct when engaging with AI and using it in our practice. And I think that's going to be the case. So keeping an eye on regulations that are going to be coming out, because with any revolution, of course, California is going to throw a bunch of, regulations in there, going in there. I see less federal. I'm seeing a lot statewide. So keeping an eye on those regulations and making sure how we're using it and when we're using it, especially we're using it in our professional settings, is okay. Yeah. And having, all those caveats is going to be important. So we're on that trend. If it's moving like, rapid fire just the last 6 months. So there'll be more of these conversations, no doubt. And especially after SOC, chat SOC fully launches, like to have another conversation, about it.
Oh, there's lots of other stuff we're working on too.
Yeah, I know. And it's all exciting stuff. It's all fantastic stuff. So we ran out of time about 5 minutes ago, but I wanted to keep on going because I find no, we're fine. This is our legal lounge. We're just hanging out, so we can have a little drink and be a little bit over. Everybody, thank you so much for listening and watching on YouTube as well. We will again have our monthly podcast for Employers Legal Lounge in February. So join us again, and thank you, my friend Mike, for joining me and giving us all of your insights and knowledge in these areas. And I hope to have you on again soon. And until then, my friend.
It's been a pleasure, Eric. Cheers.
Cheers.
Always good to see you.
Thanks for listening to the Employers Legal Lounge podcast, presented by Michael Sullivan and Associates. Remember to subscribe on your favorite streaming platform so you never miss an episode. We release new content every month, ensuring you stay informed about the latest developments in California employment law. If you have any questions, topic suggestions, or would like to be a guest on our show, Don't hesitate to reach out to us at msa.news/podcast. We'll see you next month with another episode of Employers Legal Lounge.